This series of lectures will deal on labor laws, and as we found, most of the labor laws in India were enacted during the British period. So we found among those, in particularly, the Workmen's Compensation Act and also the Payment of Wages Act, Minimum Wages Act, as well as many legislation. And fundamentally, in 2020, as in our research, we found that the Union Parliament consolidated and amalgamated all those legislations relating to labor law into four different codes, and such as the first code is relating to Industrial Relation Code 2020, the West Code of 2020, and also the Social Security Code of 2020, and finally the code relating to occupational health, safety, and working condition, and that code also was of 2020. So almost all the labor laws existing in India, pre-British period, pre-independence India and post-independent India, are consolidated and amalgamated into four different codes, and discussing about those codes in relation to the Constitution of India, as in the preamble we found the very emphasis aimed and objective relating to socio-economic and political justice. Fundamentally, socio-economic justice clearly and closely links to labor relations, working conditions, equal pay for equal work, etc. So, to achieve those socio-economic justice, in Part 4 of the Constitution, directive principles of state policy provided direction to the state to carry out certain legislation to achieve the very aim of socio-economic justice. Even in our fundamental rights, we found the very provisions relating to socio-economic justice, and that also exactly under Article 14, where we found right to equality or equality before law, and also equal protection of laws, in particularly it relating also to the labor legislations. And in Article 15, that we found the state not to discriminate on the ground of religion, caste, race, creed, sex, or place of birth. And in particularly, it also refers to socio-economic justice and equality, and there would be no discrimination, as also you found under Article 16. Equal opportunity must be provided to everyone in public employment. And besides this, also in certain particular rights, and that we found under fundamental freedoms, which we found under Article 19, Clause 1, Subclause C. It provided every citizen to form associations and unions, which particularly relates to also the workers' unions and association under the Trade Union Act of 1926. And now we'll discuss some other provisions under the directive principle of state policy, exactly as under Article 38, which particularly give direction the state to legislate such laws to bring and establish justice, social and economic and political, and also Article 39 clearly provides the state to bring out legislation for adequate livelihood, and as such Article 41 of the Directive Principle of State Policy expressly provides right to work, and also under Article 42 the directions are given to state in regards to frame policies and laws for conditions of work, and also in relation to maternity relief, and Article 43, which exactly provides decent standard of living, and also under Article 43A, which was inserted under the 42nd Constitutional Amendment Act 1976, which clearly provides that the state to endeavor and to bring out legislations for workers' participation in all the industries and factories. And as such, we found that these constitutional provisions clearly provides the state to bring out legislations to fulfill the equality criteria, and there would be no discrimination and equal right to every worker and equal pay for equal remuneration. And as such, in that connection, we would first like to discuss the Industrial Relation Code, and that Industrial Relation Code mainly consists three important and relevant acts. One is the Industrial Disputes Act 1947 and the Industrial Employment Standing Orders Act 1946, and also the Trade Union Act of 1926. So, the very Act of 1947, Industrial Disputes Act, in connection to that, we would like to discuss first the objects, then the very definitions of relevant terms as it is provided under Section 1 and Section 2 respectively, and also the very authorities under the Act as provided under Section 3, Section 9, 4, Section 5, Section 6, Section 7, and Section 10. So let us discuss about those relevant provisions of the uh, Industrial Disputes Act. So, first of all, the very objects of the Act is to establish and to bring out industrial peace, amity, and good relation between employer and workmen, and also provides regarding investigation and settlement of industrial disputes, also prevention of illegal strikes and lockouts, and regarding relief in case of layoff and retrenchment to the workmen, and also it provides for collective bargaining. And as regarding what exactly average pay it means, as provided under the Act, in case of monthly paid workman, it would be 3 completed calendar months. Week for weekly paid workman, it would be 4 completed weeks. And for daily paid workman, it would be 12 full working days. And what exactly award means under the Act, either it may be interim or final determination of any dispute by labor court or industrial tribunal or national Industrial Tribunal. So, what exactly industrial dispute means? It is being defined under the Act as disputes or differences between employers and employers, or workmen and employers, or between workmen and workmen, connected with the term and conditions of employment. And now we'll discuss the very definition of closure. Closure means permanent closing down a place of employment or any part of that employment. And what industry means, as it is defined under the Act, any systematic activity carried on by cooperation between an employer and his workmen for production, supply, or distribution of goods and services with a view to satisfying human wants and wishes. And now we'll go to layoff. What exactly layoff means, as it is defined under the Act? The failure, non refusal, or inability of an employer on account of shortage of either coal or power or raw materials, or the accumulation of stocks, or the breakdown of machinery to give employment to a workman, is considered as layoff. And now we'll discuss about what lockout means. The very provision of lockout means the temporary closing of a place of employment or the suspension of work or refusal by an employer to continue to employ any number of persons employed by him. And what exactly retrenchment means, as it is defined under the Act? The termination by the employer of the service of a workman for any reason other than as punishment by any of disciplinary action, and as such it includes for loss, confidence, failure to pass prescribed text, and due to reduction in the volume of business, for unauthorized absence from duty and continued absence without leave, or falling under retrenchment. And now we'll discuss about strike. Strike, as defined under the Act, is cessation of work by a body of persons acting in combination in a concerted refusal under a common understanding to carry out work as defined as strike under the Act. And as regarding defining settlement under the Act, it is a written agreement understanding between employer and workman in the course of conciliation proceeding. And now we will discuss the last most important definition, that is unfair labor practice. So, unfair labor practice, this provision was inserted into the Act under an amendment of 1982, which exactly means any action violating the provisions of Article 43 of the Directive Principle of State Policy in regards to decent wage and living conditions for workmen. And now, under the very Act, we found certain important authorities under the Industrial Dispute Act. and now it is a part of the Code of Industrial Relation Code 2020. So the very authorities under the Acts, the first one is the Works Committee, which consists representatives in equal numbers of both employers and workmen, and the conciliation officers. It is also an authority under the Act appointed by government for mediating in and promoting the settlement of industrial disputes. And the third authority that we found under the Act, Board of Conciliation, and it is constituted by the central government, consisting a chairman and 2 or 4 members for promoting of the settlement of industrial disputes. And the next authority under the Act is regards to Court of Inquiry, which is constituted by the government, either one or more independent person for inquiring into any matter connected or relevant to an industrial dispute. And the next authority under the Act is the Labor Court, consisting one person constituted by the government for adjudication of industrial disputes. And the next authority under the Act is Industrial Tribunal, consisting one person constituted by the government for adjudication of industrial disputes. And final authority, that is the National Industrial Tribunal, consisting one person constituted by the central government for adjudication of industrial disputes. Besides these authorities, the Act also provides for settlement of disputes through arbitrator or arbitrators, and these arbitrators or the arbitrator is appointed by the government with the consent of the parties to investigate the disputes and to submit the very arbitration award to the government. Under this section, any dispute brought into the notice of the government may make reference of such disputes to the authorities under the Act. So, this is one of the major part we found under the Industrial Relation Code of 2020. And the next important act that is falling under Industrial Relation Code is the Industrial Employment Standing Orders. So, the Industrial Employment Standings Order Act of 1946, and it applies to industrial establishment employing 100 or more workmen, and the central government or state government may apply it even to where less than 100 workmen are employed. So, after the very applicability of the provisions of this Industrial Employment Standing Orders Act 1946, now we would like to discuss how it regulates and what exactly the provisions relating to regulating, and in particularly it regulates conditions of recruitment, discharge, disciplinary action, holidays, etc. And the next one is regarding the certifying officer, who is the labor commissioner. The government may set out model standing orders, and these model standing orders were inserted under the 1963 amendment to the Act. And these model standing orders include classification of workmen, the periods and hours of work, holidays, paydays, and wage rates, shift working, attendance, and let coming conditions to grant leave and termination and suspension and the means for redressal and closing and reopening of different sections in an industrial establishment and the very provision relating to posting of standard orders as the act provides to be posted in the departments at or near the entrance in the language understood by majority of the workmen. And another important provision under the Act is relating to modification of standing orders. So, in relation to that modification of standing orders, not before 6 months of the previous orders or modification, this Act does not apply to the civil servants and those civilians in defense services and also to Indian Railways establishment. So it in particular it only applicable to all other industrial establishments and all those workmen as per the provisions of Industrial Employment Standing Orders Act. And now we'll discuss the third major act which is falling under the Industrial Relation Code of 2020 is the Trade Union Act of 1926. So, the Trade Union Act of 1926 is providing about the organization and organizational structure of industrial sectors or formal and informal groups or associations or unions to regulate the conditions of employment. Groups or associations or unions are the bodies for collective bargaining to settle trade disputes. And this particular act clearly provides the right to form associations and unions as it is provided under Part 3 of the Constitution under Article 19, Clause 1, Subclause C. So it is a fundamental right. The Act exactly defines what is trade union. According to the provisions of the Act, trade union is a combination either temporary or permanent form to regulate relations between workmen and employers or relations between workmen and workmen or between employers and employers. It also defines trade dispute as any dispute between employers and workmen or between workmen and workmen or between employers and employers. And now we'll discuss regarding the provisions relating to registration of trade unions. So, as per the provisions of the Act, any 7 or more members of an industrial establishment, they have the right to register with names, occupation, and addresses of the numbers and name of the trade union and address of its head office, the title, name, ages, etc., and occupation of the office bearers, a copy of the rules of trade union, and a statement on the assets and liabilities of the trade union. And as per the provision of the Act, the registrar would enlist the trade union and issue a certificate of registration to the concerned trade union. So, as per the provisions, the registrar has also the power of cancelling or withdrawing registration of a trade union. And once a trade union is registered, it becomes a body corporate with the right to succession to acquire, hold, movable and immovable property, can contract, can sue and be sued, and having a commercial. So, also the Act provides the general fund of a trade union which can be spent in on regarding to salary and allowances of the office bearers, and also expenses on legal proceedings or on security of the trade union or on the conduct of trade disputes or relating to compensation to members or to their dependents on in case of death, old age, sickness, accidents, unemployment, and also funeral expenses. So also it can be spent for the educational, social, and religious benefits of its members. The trade union may constitute a separate fund for political purpose for the promotion of civil and political interest of its members in connection to election expenses and also expenses of its members holding any constitutional position under the Indian Constitution. And besides that, the Trade Union Act of 1926, which is now the part of the Industrial Relation Code of 2020, provides certain privileges, and such privileges are the very immunity from punishment as under Section 120 of the IPC, and also certain other privileges provided in regards to criminal conspiracy and immunity from civil suit. So also a minor can be member attaining the age of 15, but to become an office bearer, he must attain the age of 18 years. A trade union can anytime change its name with the consent of its total members. Also, the Act provides dissolution of a registered trade union if applied by 7 members with the signature of the Secretary of the Trade Union to the register, and in such the assets shall be provided accordingly by the register among all its members. So, these are the provisions that we found under the Trade Union Act 1926, and which is now consolidated and amalgamated into a particular code, and that is the Industrial Relations Code 2020. So, in that connection, finally, we would like to discuss about the major trade unions in India. So, those major trade unions of India are as such the All India Trade Union Congress, which is associated and affiliated with the Communist Party of India. And another trade union is United Trade Union Congress, which is associated with the Revolutionary Socialist Party in India. And the next one is that Hind Mazdoor Sabha, which was constituted in 1948, is identified with the Samajwadi political party. And the major trade union in India is Bharatiya Mazdoor Sangh, which was established in 1955, is affiliated to Bharatiya Janata Party. And another important trade union is the Center of India Trade Union, and which is associated with the Communist Party of India, Marxist. And the most important trade union that is affiliated to the Congress Party is the Indian Trade Union, Indian National Trade Union Congress. And besides this, there are number of many trade unions in India, as such the All India Railways Federation, Bharatiya Khet Mazdoor Union, Central Trade Union Organization, which is the largest body. And also in India, the first trade union was constituted by the Bombay Textile Mills Workmen in 1851, and in regards to Calcutta, it was established in 1954 as the Calcutta Jute Mills Workmen. So, besides this, at present we found almost in every sector the trade unions. In the banking sector, we found the All India Bank Officers Federation and also All India Bank Employees Association. So, almost in every sector at present, we found number of trade unions are functioning. So, at present, as all these acts are part of the Industrial Relations Code of 2020, and in brief, we have discussed the very relevant provisions connecting to industrial relation, as in particularly the Industrial Dispute Act and also the Employee Standing Orders Act and also the Trade Union Act 1926. So this lecture completely devote reading industrial relation, the conditions of work, and also in regards to the right of workmen to form trade union, and finally the major trade unions in India. In India, so in our next lecture in this series, we will discuss regarding the Wage Code 2020, which also consolidated and amalgamated relevant laws on wage and insurance as provided under the Wage Code of 2020.